Ladies and gentlemen, today is Tuesday, February the 8th, 2022. I hereby call the Civil Justice Subcommittee to order. Ms. TJ, take the roll.
Good morning. Representatives Clemens, Curcio, Farmer, Garrett, Griffey, Ogles, Parkinson, Ramsey, Chairman Russell. Chairman, you have a quorum.
Thank you. And members, are there any personal orders or announcements this morning before we begin? Representative Parkinson.
Thank you, Mr. Chair. I've been here early 2 weeks in a row. Thank you.
And we thank you for that. Representative Farmer. Or I'm sorry, Curcio.
Thank you, Mr. Chairman. I just want to say I was not able. I was in the building, but I was not able to join last week. So honored to see you swinging the gavel. Glad to serve on this committee, and also want to wish my son Churchill an 11-year-old birthday this morning. So happy birthday!
Thank you. All right. Seeing no other personal orders or business, we'll start with House Bill 1832 by Leader Lamberth. We got a motion and a second. Leader Lamberth, you are recognized.
Thank you, Mr. Chairman and members of the committee. We recently went through a redistricting process in the House and Senate and for Congress. Unfortunately, the judicial branch does not have a process in place where that is something we look at on a regular basis. So this bill will not change anything for the elections that are occurring this year, and really nothing for several years, but it would say that no later than July 1st of 2031, that there will be a committee and a task force put together to specifically bring back to the legislature, and it's represented by judges and district attorneys and public defenders and the folks that it would affect, and also citizen members of the committee, to truly look at all of this and make a determination: are our judicial districts, do they serve the people of Tennessee well or not? Now, I will say right off the bat, I certainly hope that this task force is appointed much earlier than July 1st, 2031, but that would be kind of the latest that it could be appointed, and then it would have to have a report back to this body by the January thereafter. So July 1st, 2031 is when this would set it up as the latest this task force could be appointed, and it would have to have a report back to us by the following January, so about 6 months later. That's what the bill does.
Do we have any discussion or question? Representative Farmer.
Yeah, and thank you, Mr. Chairman and Mr. Leader. I had just a couple questions for you. Does your bill set out, and I apologize, I may have not went through it as well as I could have, does it set up the makeup of that task force at this point in time, or is that something that we're going to do later?
Representative Lamberth.
Thank you, Mr. Chairman. And Mr. Chairman, it does set up the makeup. It's comprised of 11 members, 3 current trial judges, 1 from each grand division, appointed by joint action with the Speaker of the House and Senate, 3 current district attorney generals, again, 1 from each grand division, appointed by the Speakers of the House and the Senate, 3 current public defenders in the same like sign, and then 2 citizen members, 1 appointed by each speaker, and the citizen members must reside in different grand divisions of the state. Obviously, there's only 2, so you can't have 1 from all 3, but they would be in different ones. So if one's from the middle, the other would be from east or west, and vice versa. And then the Speaker shall jointly designate one of the members to serve as chair of the task force.
Okay.
Chairman Farmer.
Yeah, and I think I just don't want to get us in a situation like our BEP is with our school and our education dollars when it comes to how we allocate our judges. I just want to be sure that whatever we do, we take into consideration those towns that may, at any point in time, have 100, 150,000 more people in it. That means more public intoxications, more DUIs, just more crime, unfortunately, whether it be purposefully or not. Just want to be sure that those towns that are taken care of and all that's taken into consideration when we do this. I know we've got some time, but it'll be here before we know it. So, and I know we just went through I think we finished up a weighted caseload study just here very recently. I hope that information is used in some capacity, added on to, maybe. But I'm going to be voting for your legislation, sir, and hopefully we'll get it right. Thank you.
Leader Lamberth.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. That's exactly what all of that we would hope would go into any of these reports. And again, no action would be taken on any kind of redistricting until it comes back to this body, and this body would have a vote on that.
Representative Parkinson.
Thank you, Mr. Chair. My question was actually answered, but I do want the leader to know that your motion came from a good Democrat. Just wanted to know.
Leader Lamberth.
Thank you, sir.
All right. Next up is Representative Clemens.
Thank you, Mr. Chairman. And Leader Lambert, thanks for this bill. I would love to see something like this for legislative districts as well, because it makes so much sense to have, you know, kind of an outside body make recommendations in seemingly an independent fashion. The Speaker of the Senate and the House are going to be appointing all these positions. Has there been any consideration of allowing the administrative office of the courts or anyone other than the speakers to appoint this body?
Leader Lambeth.
So that was discussed, I believe, early on in this, but I mean, that it is a legislative committee, and so I don't know that just from a strict separation of powers standpoint, that the AOC could appoint members to a committee that is a legislative committee. And so the Speaker of the House and the Senate would appoint the members. I would hope that they would discuss with the AOC, you know, what judges and district attorneys and public defenders that would be good on this and consult with them. But at the end of the day, the buck really stops with each speaker as to who would serve on this body.
Representative Clemens.
Thank you, Mr. Chairman. And also getting to the, I'm a little concerned that some of the criteria are not outlined. I know the weighted caseload study that was represented by my friend, the chairman, Farmer, you know, certain criteria that should be evaluated or weighed by the parties to whom you've appointed to this body. Were any criteria specifically contemplated, or do you envision specific criteria such as caseloads and the like being considered?
Leader Lambeth.
Yes, sir. Subsection C actually lays out some of that on the weighted caseload study and population density and everything else. It is something that definitely should be considered.
Representative Clemens.
Okay, and then also one last concern is we have each Grand Division represented and different judges and AGs and public defenders. Is there any requirement or consideration given to ensuring that we have different types of judicial districts, whether, you know, perhaps in a metro district as well as a rural district represented in all these appointments, because they obviously have different perspectives and different concerns and considerations. So I just want to make sure we're ensuring that everyone is represented, not just the 3 Grand Divisions.
Leader Lambert.
I mean, given the number and the size of this committee, it would be almost unconscionable if, you know, there was not representatives from both urban and rural areas, but that would be a conversation to have with the 2 speakers at whatever time this task force would be appointed. But I again, will say on the record, I mean, I think it is a very valid point that there would need to be, while it's not written on the page here, I think the intent would be that you would have a very diverse body of individuals that come from both rural and urban areas and, quite frankly, different backgrounds of the law. I mean, I would hope that they would have folks that, you know, both criminal and civil and, you know, within the law that, you know, can actually look at this. A lot of this deals with criminal court judges and DAs and public defenders, but obviously it would affect your civil judges as well.
Representative Clemens.
Thank you, Mr. Chairman, and thank you, Mr. Leader, for clarifying that.
All right, Representative Griffey, you're up.
Thank you, Mr. Chairman, and thank you, Leader Lambert, for bringing this bill. My only comment would be, I sat through the last judicial redistricting committees, and Tony Childress, a chancellor from over in Weakley County, I believe, did an awesome job advising the committee and helping the committee. There's also a chancellor from East Tennessee who did the lion's share work, and he just did an awesome job, and I apologize, I can't remember his name. I thought I had it in my phone, and I can't find it. But I would suggest the Trial Judges Conference has a lot of valuable information. If there was a possibility to expand the committee or advisory membership and have the Trial Judges Committee vote and maybe nominate some people to sit as advisory positions or something. They've just got a lot of good information. I know you know that and stuff. So, but anyway, that would be my only comment. But thank you for this bill. I think it would be a good bill.
Leader Lambert.
Thank you, Mr. Chairman, and thank you for that. That's why we have 3 current trial judges on there. And again, I definitely think that they should talk amongst themselves and make suggestions to the Speaker. But since it's a committee of the House and Senate, it kind of has to be the speakers that would appoint that. But yes, they definitely should be involved. And quite frankly, to try to do this without input from the trial judges wouldn't make any sense at all. So they definitely need to have a seat at the table.
Representative Griffey, got anything else? All right, seeing nobody else on the list, we're now voting on House Bill 1832 to send it to the Civil Justice Full Committee. All those in favor signify by saying aye. Opposed, no. The ayes have it. The bill moves on to Civil Justice Full Committee.
Thank you, Mr. Chairman and members of the committee, and I too will share what the chairman said. It's mighty fine to see you up there swinging the gavel, sir.
Thank you.
Thank you.
Next up is item number 2, House Bill 1542 by Representative Weaver. And we have a motion and we have a second. Representative Weaver, you're recognized on House Bill 1542.
Thank you, Chairman. Thank you, members. This bill has been rolling around for quite some time, and it has been it is a extreme concern of mine. It's about property rights, what's going on in your backyard, but it's not against new development. It's not against our districts moving forward. But I do understand, as I currently understand the information I have today, that the situation that this bill pertained to, this was brought to me by letters from my constituents who were concerned about this. And if you read the bill before you, it simply, at the merit of the bill before you, it just offers an alternative way for you to run utilities should the utility line go behind backyards of individuals who do not want this, and then put a dedicated green space on it. It's concerning. It's an issue that many homeowners don't want to have a greenway in their backyard and lose their privacy on their pristine land, especially in this situation when they have equestrian, they have horses, they have animals, and they're used to the stream behind the home. So as I understand it, Chairman, this bill is general subbed in the Senate. And I also understand that this bill has also, I've been told that, as I understand it now, there is no dedicated green space or greenway on the calendar right now for this particular reason why this bill was implemented. So with that being said, I'd like to go ahead and take this off notice, and I appreciate the patience of the commission.
Thank you.
The committee, excuse me.
Thank you, Chairman Weaver. And seeing no objection, this bill is referred to special calendar to be published. We got Chairman Farmer.
And thank you, Mr. Chairman. I'm sorry, I was trying to raise my hand there, but I wanted to let Representative Weaver know, and any of her constituents may be watching, how hard she's worked on this and brought those signed affidavits and petitions with her. And I respect the work you put in on this. I know it's general subbed in the Senate, but just wanted to recognize you for that.
I thank you. Thank you. Thank you very much, sir. Appreciate that.
Okay, seeing no one else, and seeing this bill's been calendared 3 times, and seeing no objection, this bill is referred to a special calendar to be published with the final calendar.
All right. Thank you.
Thank
you,
you.
members.
Next up is item number 3, House Bill 1882 by Chairman Rudd. Chairman Rudd is not in the room, so we'll go to House Bill 4, which is Chairman Rudd. So we'll move both House Bill items 3 and 4 to the Hill, and we'll go to item number 5, Chairman Baum. Chairman Baum, you're recognized on House Bill 2082. We do have a motion and a second. Chairman Baum, you're recognized.
Thank you, Chairman Russell. This is a bill that would allow municipal courts to expunge from records municipal violations. Currently, something very similar can occur at the state level with some misdemeanors. This is a bill that would clarify that a municipal court could do the same thing for municipal offenses. It would only pertain to municipal offenses, and the state would not be under any obligation to perform a similar type of expunction. I think the only time a municipal offense would even be on record at the state would be for some type of vehicle violation with the Department of Safety.
Are there any discussions? Representative Parkinson.
Thank you, sir. You can call me Chairman. I am the chair of the Black Caucus. Just so you know. Thank you, Mr. Chair. Yes, and thank you for bringing this bill. I would actually like to sign on to it. What's the process, though, for them to get these items expunged?
Well, the person who has the violation on their record would have to petition, and then the court would have to evaluate whether the expunction is warranted. And I'm sure in some cases the judge would feel like it is, And in some cases, they would feel like it's not. So it would be handled on a case-by-case basis, whether it's warranted or justified.
Okay. Thank you, sir.
Representative Griffey.
Thank you, Mr. Chairman, and thank you, Representative Baum, for bringing this bill. I'm curious as to what's the extent of municipal traffic violations. I assume that the municipal courts can currently handle or would have jurisdiction to expunge. I'm assuming speeding, parking, tickets. Do they handle any DUIs or anything?
I think it would be largely traffic violations like that, but it could be other things. I'll give an example. A municipality might have a noise ordinance. Maybe an 18-year-old has a loud party and violates that, and that goes on the individual's record. And then 20 years later, they'd like to have that taken off their record because it's 20 years since they had the loud party.
Representative Griffey.
Thank you. Are they handling any Class A misdemeanors at all?
I don't think so. I think all city violations would be
C misdemeanors?
I think so, and civil, not criminal.
Representative Griffey.
Could we go to legal? I'd just like to get a clear picture of the extent of violations that could possibly be expunged, that, maybe drag racing or something like that. If we could get some clarification from legal on that, please, Mr. Chairman.
We sure will. We're out of session for legal.
Michelle Fogarty, Legal Services. It's my understanding that according to the Criminal Court of Appeals, a municipal court does not have jurisdiction over criminal misdemeanors. They only have jurisdiction over municipal ordinances. They can act, municipal ordinances, they can involve, they can duplicate some state offenses like speeding and that sort of thing. So the municipal court's jurisdiction over criminal misdemeanors is limited to the violation of the language of a state criminal statute incorporated by cross-reference into a municipal ordinance. And it is civil, whereas the violation of a state criminal statute is criminal. So it's my understanding that municipal ordinance violations are civil and they are not criminal. And sometimes when they can enact an ordinance, municipalities can enact an ordinance that tracks a criminal statute such as speeding, but that again would be an ordinance violation and not a state criminal offense.
Representative Griffey.
So do we know if any municipal courts have jurisdiction, whether they've done a civil DUI or something?
I believe some municipal courts have concurrent jurisdiction with some general sessions courts. And I think in those instances, they would be acting as a general sessions court and a conviction would go on a criminal record. Whereas when they're acting as a municipal court, the violation is a municipal ordinance violation.
Thank you, Mr. Chairman. Thank you, legal.
Representative Parkinson, you got a question for legal? Okay, unless anybody else you got a question for legal, Chairman? I don't know if it's for legal or not. I'll wait and ask you. All right, we're going back in session. And Representative Griffey, you have anything else?
I'll defer to Chairman Curcio.
Okay, Chairman Curcio, you're recognized.
Thank you, Mr. Chairman. And our kind of side conversation here is, this committee and the others that I sit on have done a lot of work on expunction. I'm trying to understand, though, what civil fines go on your record. Like, what can you describe maybe what the impetus for the bill was, or can you give us an example of what would need to be expunged?
Chairman Baum.
Any violation of a city ordinance, could be a traffic violation, could be a violation of a noise ordinance. This would be on your record in the sense that if someone did some kind of a search, maybe even an online search, it would turn up. So it would become a matter of record in that sense. This would be a way of expunging that from your record. And it was brought to me by the Tennessee Municipal Judges Conference. They would like the ability to expunge in the same way other courts at other levels are able to. But they don't believe that they currently have that power to expunge municipal violations.
And Chairman Curcio.
Thank you. So I guess I'm just not aware that, so if I get a parking ticket, I mean, that's on my criminal record? Is that, I mean, it's a civil.
Chairman Vaughn.
No, it wouldn't be on your criminal record. These only involve civil violations. Any municipal violation is only a civil violation. None of them are criminal. There would be no expunction of anything on a criminal record. This would also only expunge the records at a municipality. Municipal entities have their own records, and so these are violations that are on a city's records. They're not, we wouldn't be expunging anything at the state level or any other level, but municipalities have their own records of different violations, and so this would remove that from those records.
Chairman Curcio.
Thank you, Mr. Chairman. Okay, so final clarification then. So what you're saying is that these things don't show up. If somebody runs a criminal background check on me, that they're not showing up there. So it's literally just the record, I guess, that municipality would keep on me. So I'm a long-term resident of the city of Dixon, and if I'm notorious for my traffic fines there and my loud music, then I can go and right, I am. And the judge and the city fathers and mothers will absolve me of that forevermore.
That's correct. This would only pertain to expunctions from municipal records.
Okay, thank you very much.
Representative Parkinson.
Thank you, sir. Thank you, Mr. Chairman. So just scenario, I'm looking for. I guess I'm looking for a time frame. So if Chairman Curcio gets pulled over for playing Young Dolph very loud, and he gets a ticket and it's on his record. At what point can he request this expungement to get the noise violation off of his record?
Chairman Baum.
The bill doesn't have any time lengths specified. It would be at the municipal court's discretion, and they could certainly turn down the request to have it expunged from the record.
Okay, thank you, sir. Okay.
All right, Representative Griffey.
Thank you very much. Let me ask you, do you know if there's any civil ordinance for harassment or something like that, something that relates to actions against another person?
Chairman Baum.
I don't know, and I suspect that it varies by municipality. So, and that if that's a possibility, because I'm not sure either, it just kind of gives me some pause. You know, suppose somebody's got civil harassment. There was a finding that they've harassed somebody, but maybe there's something going on in another criminal court regarding to no contact or something like that. That gives me a little bit of pause. The other issue that kind of gives me a little pause is: are there any restrictions on how much a municipality could charge for the expungement? It seems like this is kind of a blank check. They could charge $350, $400, whatever, maybe $100. I don't know, but that gives me a little concern too. I kind of wonder if maybe I'm not necessarily opposed to the legislation. I kind of wonder maybe some guardrails if we're going to do something like that. And so I'm more inclined to vote it out of subcommittee and maybe work on it at full committee. So thank you, Mr. Chairman. Thank you, Representative Baum.
All right, next up is Representative Garrett.
Thank you, Mr. Chairman. Chairman Baum, this says broad. It can be applied in a very broad sense to kind of echo Representative Griffey's concerns. There's no limitations. There's no what it can apply to. It's just very, very broad, which makes me nervous to pass a statute in an expungement sense when there's absolutely no guardrails on what it applies to, on what can be expunged, et cetera. So if it's appropriate, and if you don't mind, I don't believe I can support it coming out of subcommittee to go to full with not knowing what we're passing and how that's going to be applied. It seems like a city of Dixon versus the city of Goodlettsville could apply this in very different ways. And when a statute can be applied in different ways, we have an ambiguous situation where I'm afraid the statute could be unconstitutional on its face. And so I've got some concerns there. So if it's okay with you, I would recommend we roll this to see if we can kind of narrow its definition to make sure we're doing what you intend to do, where a kid 18, 19 years old can look at something that they may have been fine with that pops up in an employment sense that we certainly don't want. That he was just too loud, be on a civil record, and I'm not even sure if that exists outside of the criminal world. What are your thoughts on that? If we can sort of craft this a little bit better, so we know what we're dealing with.
Chairman Baum.
I can provide you some information. This bill does not address a fee that would have to be paid in order for the process for the expunction to occur. It doesn't address a time limit. It would apply to any and all municipal ordinance violations, but it doesn't require expunction. It just says that the judge has the discretion to consider such a petition and grant it if he or she believes that would be appropriate. In the same sense that this can be done in other courts and at courts at higher levels for misdemeanors and I think some felonies. So this is sort of following that, I guess it kind of follows with that trend, but at the municipal level. And really there are no restrictions on what kinds of violations would be eligible for expunction, but it would be at the judge's discretion, and the judge could turn down the petition just like a judge could at any other level.
Representative Garrett.
And I think that's one of the problems is that we don't have, for one, if it's 20 years go by and you're getting something expunged 20 years later, I have a problem with that. That's way too long. If you want something expunged, you should do it within a fair amount of time. So there's no guardrails on when does that run when someone can come back to court to get something expunged in that procedure. And I'm not aware that, let's say, Davidson County, if they had municipal judges that would hear this like Sumner County would, like in Gillettsville, Hendersonville, and Gallatin, they do have a municipal judge that would hear this, and I'm not sure what that procedure would be in a city like Davidson County or Shelby County that may not have a municipal judge that would hear this. It'd probably be their general sessions judges, and then you've got a fee issue. If you're having several folks come at any time after all 20 years of a violation coming back to get something expunged, tying up the court system without that fee. I'd be afraid that Shelby County or Davidson County would be certainly reasonable to charge a higher fee because of the amount of potential expungements that they would have versus a county like mine where we wouldn't have as much population-wise. So that's why I think there's some issues with how are we going to hone in on what we're doing here. So I still have some concerns on the legislation. So thank you, Mr. Chairman.
Chairman Baum.
At the will of the committee.
All right, Representative Ogles, you're recognized.
Thank you, Chairman. To the sponsor, I recently saw an incident where that this pertains to, and what it was is a domestic incident where somebody actually breaking in and entering with a weapon to somebody's house. Because of the caseload and some good lawyers involved, that got pled down pretty much to a civil restraining order in that municipality. So it was something that, in all honesty, was a felony. Good lawyers got involved, ended up being just a civil restraining order in that jurisdiction. So what I'm afraid of is, though you have good intent here, you could really have people that have done some pretty egregious things with the right lawyers and the right caseload. It turns into a local civil matter, and then it's not, and then it's expunged. So I know your intent, but I'm afraid that there's not good guardrails on this, and this very well could turn into a discombobulated system of not holding people accountable if applied wrong.
Chairman Baum.
I think it would. I think you're correct that it would ultimately be at the judge's discretion on how to handle that.
Representative Ogles.
And as much as I value our judges and their opinion, sometimes, and I think it's the job of this body to put very articulated guardrails on them sometimes, and so they apply the law and apply the words that we put in writing when they do their job. But thank you to the sponsor.
Chairman Baum.
Thank you.
All right, not seeing anyone else on our list, I do have a question. Could you describe like a central database these convictions are housed under? Like if somebody does a background check to find out where these municipalities' convictions are located?
My understanding is that they're formally on record within the municipality, but it's also my understanding that some of this information is publicly available so that someone conducting a search could uncover it.
So if a background check was done, more than likely it would have to be done for each municipality for it to show up?
I don't know the answer to that. I wouldn't think that this would affect a background check, except to the extent that if the record was expunged of the violation, then it just wouldn't be there any longer. But if background checks currently must look through the records of multiple municipalities, I wouldn't think that this would change that.
If it wouldn't show up, what would be the need to expunge it?
If it's not expunged, I think it would show up through a background check. But whether the person conducting the background check needs to look at different municipalities separately, or if there's one central database, that I don't know the process of the background check.
Okay, thank you. And Representative Griffey, you're recognized.
Thank you, Mr. Chairman. I apologize for being long-winded on this. Here's what I can foresee happening, though. You've got a civil restraining order. Somebody violates that, and that's handled through municipal court. There may be a finding they've actually violated the order, something like that. Later on down the road in divorce proceedings or some other criminal matter, prosecution or, a plaintiff or a victim may bring up that the accused or the defendant has done this in the past or something. It's a basis to make a decision what to do in a present charge or something like that. If the stuff gets expunged, then that's, no longer available. I think if we're going to entertain something like this, there ought to be some guardrails, maybe something like a 5-year, no problems kind of deal or what, similar to what we do in circuit court expungements. So I'll vote for it now if you want to get it to full, but I would not be able to support it in full without some guidelines on it. So thank you, Mr. Chairman. Thank you, committee.
Chairman Baum.
Thank you.
All right, Representative Parkinson.
Thank you, Mr. Chair. I just wanted to say guardrails, and did want to ask you also, it seems like guardrails is the word of the day up here, so I did want to ask you, though, are there, right now, under present law, or I guess, maybe the municipalities have it, is there a time frame when some of these things just roll off of your record anyway?
Chairman Baum.
Not that I know of.
Okay. Thank you, sir. Guardrail. Thank you.
All right. Not seeing anybody else on the list. We'll now be voting on House Bill 2082 to send it to Civil Justice Full. All those in favor signify by saying aye. Opposed, no. All right. Miss TJ, will you take the roll or the vote?
Representatives Clemens, Curcio?
No.
Farmer?
Aye.
Garrett?
No.
Griffey? Aye. Ogles?
No.
Parkinson?
Aye.
Ramsey?
Aye.
Chairman Russell?
No.
Yeah, I'll vote.
Okay, bill fails.
Thank you all.
All right, next up is item number 6 by Representative Parkinson. Representative Parkinson's House Bill 1765. Do I have a motion and a second?
Second motion.
We have a motion and a second. Representative Parkinson, you're recognized on House Bill 1765.
Thank you, Mr. Chair. Mr. Chair, do you mind if I approach the well so my back is not turned to any of the
Sure.
members? Thank you. Thank you, Mr. Chair. Good morning, members. Thank you for the motion and second. What this bill does is, it creates a hold harmless for 501c3 organizations that are providing services to our communities, such as feeding, clothing, housing, in our communities. And the reason I brought this bill because I had a couple of my church's pastors that said that we would love to do more, but our concern is the liability, and so that's why we brought this bill.
Do we have any discussion or questions? Chairman Farmer.
And it says in section, look like A, subsection 2, there, services includes but is not limited to providing food, providing housing, and providing shelter from adverse weather. Fine with all those. What else could it include?
It's just community services that they're providing to the community that, some of our 501c3 organizations. I didn't have anything specific, honestly, other than those things. That's just the way legal drafted it up. So my purpose was for providing that are feeding, in our communities, providing food, that are providing housing for homeless individuals, and providing warming and cooling centers for, in times where, the weather is adverse and you got people that need access to those.
Chairman Farmer. Chairman Farmer.
I'm finished with that. With that, there. You may come back to me. I'll raise my hand.
Representative Garrett.
The bill seems to be providing wide open standard for simple negligence for any charity to get out of any type of simple negligence regarding what services. So if there's a medical services that a charity hires a medical person to provide whatever type of the basic medical services, and those medical services fall below the standard of care, now we're raising that level to a gross negligence for this charity to provide something that may happen to someone that comes on their property. I have a real concern about blanketing immunity for simple negligence if they're providing some sort of care for someone and that care falls below the reasonable standard of medical care that's otherwise defined in many, many statutes and litigation across the state. This is going to significantly change that. Can you address that for me, please?
Absolutely.
Representative Parkinson.
Thank you, Mr. Chair. And members, so that we're clear, I don't mind getting this bill amended to specifically for these areas that I intended it to be. And so that will be just simply removing the but not limited to language. And I don't have an issue with that because my intent was always, providing food, providing housing, clothing, and shelter in adverse weather. That's always been the intent.
Representative Garrett.
And I appreciate you being able to do that. I think the idea and the intent is fabulous. We need these services conducted without folks, charitable organizations, surely worrying about who's going to turn around and sue them for providing services like feeding folks and providing housing. That is, I applaud you for bringing this legislation. But one other thing, I know you have a charitable organization is defined as in the federal code, but I would also look out making sure that that charitable organization is registered in the state of Tennessee as a nonprofit, not necessarily a 501c3, that's something different, but at least they've registered. Most churches do, but as you know, in your community, there's many, many nonprofits, and I would say that they need to also make sure that they're actually a registered nonprofit with the state of Tennessee, so we know they're an actual entity, right? If that is just a suggestion as you further craft your amendment, take a look at this, I would appreciate something like that as well, if that makes sense to you.
Representative Parkinson.
Mr. Chair, and if it's okay with the committee, I actually received those as friendly amendments, and if we could, attach them verbally now, if you're okay with that, I would be, fine with that, changing that language now.
Preferably, I don't know if I'm still recognized, sorry, Mr. Chairman.
We would need to roll it to do the amendments.
Okay, that's fine with me.
Representative Garrett, do you have
That was all, because in my opinion, that's a significant substantive change to the legislation that we would need language in order to make sure we get the proper intent.
Representative Parkinson, would you like to roll it a week or two?
Well, I wanted to ask before we do that, if the committee's okay, can we just move it out and with my word, my promise that we'll amend that language going into full committee?
Yeah, we got quite a few on the list.
Okay, yes, sir. Okay.
So,
can we hold up on the roll till we hear from the other members then?
yeah, that's fine. Okay. Chairman Curcio, or well, actually, I'm sorry, Representative Garrett, you good?
Thank you, Mr. Chairman. Most of my concerns were met. My recommendation was going to be to strike, but is not limited to, and then to state nonprofit. So, with that, I feel much more. I know what the intent is. We need these services, as Chairman Farmer pointed out. Just want to make sure that we don't get any mission creep under that.
Perfectly fine with it.
All right. Next up is Representative Clemens.
I don't know that I raised my hand, but I'll take it, Mr. Chairman. Thank you. I just want to applaud the sponsor for introducing this legislation. I think public policy dictates and should be guided by encouraging others to act in the best interest of their fellow man and neighbors. So I think that's the intent of this legislation. And I appreciate my fellow committee members' willingness to roll this and let us get this cleaned up to make sure we have these legal issues resolved, because I think at the end of the day, we'll all be able to agree on the intent and purpose of this legislation. So thank you, Mr. Chairman. Thank you, sponsor.
All right, Representative Griffey.
Thank you, Mr. Chairman. Thank you, sponsor, for bringing this legislation. I understand the intent. Here's what gives me some concern. So if someone's providing housing services or something for homeless and other folks, and they've got a site or facility, and they're also providing services for children, and they may not know the background of some of these, the criminal history background of some of these folks that are providing services. What if a children gets put in a situation where there's a convicted child pedophile sex offender? Is that going to be gross negligence, or is that simply negligence, and they're going to be able to avoid it? So while I understand the intent, I do have some concerns that there might be some unintended consequences by just granting them gross negligence. Somebody could be injured and hurt and damaged and have very little recourse for a grievous wrong. So I hope we all fully take that in consideration, think about that. So thank you, Mr. Chairman. Thank you, sponsor.
Representative Parkinson.
Yes, sir. And I think that would be, honestly, that threshold, I guess that would be laid out in the courts, and, it doesn't stop anybody from a cause of action, if I'm not mistaken. But I think legal could probably better answer that question for you in that scenario, because I don't know, honestly.
Representative Griffey.
Thank you. And to me, that's going to be a jury question. And the issue then becomes, is someone who was injured by the negligence or gross negligence of one of these service providers, our attorney's going to be willing to take the case if there's a much higher bar for gross negligence. So actually, while you may be wanting to do some good, we may be doing some really bad on the back end, unintended, of course. But so that's what gives me some concern. So maybe there's a way to address this through amendment or not. I'd have to sit and think about it some more. Thank you.
All right, Representative Ogles is next, and we'll get to you, Representative Garrett.
Thank you to the sponsor. Thank you, Chairman, and to the sponsor. I'll just echo the sentiment of Representative Griffey and kind of caution the committee. I think we've already done some carve-outs for some other groups. I know we did raise the bar for teachers. I think we did raise the bar for some utility worker providers last year. And my concern then is, as it is now, is once we start carving out different groups of individuals, we're going to get hit with carve-outs for everybody that employs a lobbyist on the Hill. Because once we do for one, we're going to pretty much, we started the slippery slope of doing for many. So as much as I highly appreciate what you're doing, I do think we need to be very limited in the application and the precedent we set going forward of raising the bar from that negligence to the gross negligence. Thank you, Chairman.
Representative Parkinson.
Yeah, thank you for that, and completely understandable. However, these are the organizations that are taking the burden off of government in our communities. And so our purpose is to encourage more of that so that it's not a burden on government to provide, all of these services that are being provided, in our communities. So this would help to encourage more people to be, to provide more services in our community, more organizations rather, to provide more services in our communities.
Are you good, Representative Ogles? All right, Representative Garrett, you're next.
Just as we continue to think this through, just for your thoughts going forward with the legislation that's currently in front of us, I believe we need to make sure that the upward standard, the gross negligence rather than simple negligence standards, needs to be related to the actual act of providing the services that this particular charity or church would be creating. In other words, here's an example that I can think of off the top of my head, is that if you're on one side of the church and you're providing the food, for whatever purposes you're providing for the food, but on the back end of the church, there's a pothole back there that's been there forever, and the church just decided not to fix it, that's completely unrelated and not close to the vicinity of wherever you're serving these foods, your bill would create a gross negligence standard for someone tripping in the pothole, breaking their teeth, landing on the concrete, et cetera, where the church should otherwise be responsible for that, right? And so we don't want to create that particular instance where we've got several things that happen on the property of a church or a nonprofit where then they get shielded for their negligence, and it's simple negligence for something that's completely unrelated to what services they're providing. So I would say that needs to also be contemplated under this legislation, so we don't create a blanket liability shield for that difference of standards for negligence and gross negligence. Okay, that's all, Mr. Chairman. Thank you for that.
Representative Parkinson.
And thank you for that. And thank you for that, Chairman. That's actually the intent and the spirit of the legislation, specifically for that service at that time that they're providing. And so we'll make sure that language is in there also. Yes, sir. Thank you.
All right, Representative Clemens, I see your hand this time.
Yeah, thank you, Mr. Chairman. I just want to clarify, and it's like I said earlier, with the purpose of public policy is intended to favor policy that encourages people to help other people. Legislation that we passed last year that was referenced with regards to increasing the threshold for teachers was to shield teachers who were disciplining students. That's very different than a Good Samaritan versus the purposeful conduct of an individual. And public policy differentiates between those. So it would be incorrect to compare this type of legislation with the legislation that we previously passed with regard to teachers. So I just wanted to point that out. Thank you, Mr.
Representative Parkinson.
Thank you.
All right, Representative Ramsey, you're up next.
And thank you, Mr. Chairman, and I think this is a very timely piece of legislation. I am totally behind it. I'd like to sign on it and help these learned folks make it a good, perfect piece of legislation. But I think it really reflects what we've been trying to do up here for the last decade, which is encourage public service. We've done that in instances of Good Samaritan care on the side of the road, Second Harvest food banks, giving them some protection. AED availability, we gave them indemnity, high school internships for companies that want to hire high school students. We've addressed that. So I think we're on the right path. I want to be of any help that I can in getting this passed. Thank you very much.
Representative Parkinson, you have anything?
Yeah, yes, Mr. Chair, if there are, I don't want to step on anybody else that had any comments or questions, but if there are, as soon as your list is exhausted, I'd be happy to roll this bill before we can get the amendments on it.
I got two more. Representative Griffey, you're recognized.
Thank you very much. I appreciate the intent of the bill. Here's my concern. With this population group, mental health issues are a serious component in a lot of the cases. I think everyone would agree on that. If someone's providing services for displaced single mothers or something with kids or something like that, if someone got placed with someone with severe mental health issues or criminal history or something like that, would a reasonable, prudent person do that? That's the ordinary negligence standard. But the gross negligence standard is wanton disregard for the concerns and safety of someone else or whatever. It's much higher. Mm-hmm. I'm concerned if we pass this, somebody could get seriously injured, and a reasonable, prudent person would take ordinary steps to try to prevent things from happening. And I'm afraid this is just going to move the bar so far that people are going to be potentially suffer with little recourse and unable to get an attorney to try to assert those rights because the bar has been raised so high. So that's my concern. I don't know that I can support it. Thank you.
Okay.
Yeah. Yes, sir.
And Mr. Chair and Representative Griffey, I take your concerns very seriously, and I mean that. And I would be happy to sit down with you also and see if we can address those concerns, because I think this is a good bill. Especially because I think I understand where you're going. Like if somebody is providing housing or a homeless shelter and they let the wrong people in, and so I would like let's me and you sit down together and see if we can get with legal and see if we can address that to make sure we address those concerns, because I'm happy to, honestly.
Representative Ogles.
Thank you, Chairman, the sponsor. I did have one other consideration to think. We need to think through. And I think I know the answer to this, but aren't these organizations already exempt from some of the standards as far as like the health department certification for doing food service? For instance, I build restaurants from time to time, that inspection from the health department is very stringent. I mean, there's temperatures on the coolers, there's repetitive systems, there's splash guards on sinks. If I'm not mistaken, I think our churches are already exempt from a lot of those standards as far as a yearly inspection.
Representative Parkinson.
Yeah, and thank you for that. I know that we have an organization that provides probably one of the largest job fairs in the city of Memphis, and college fairs and health fairs. And we do food out there at that event every year also, but we're inspected by the health department, so we're not exempt from any health department standards. I know they come out there and they make sure that we're doing everything that we're supposed to do because we're feeding the public.
Representative Ogles, you have anything else?
No, Chairman, just maybe to follow up. If we're going to roll this, we can just look at that as we go forward anyway. Thank you, sponsor.
Representative Parkinson.
Yes, sir. Do you mind if I roll this before we can get, the amendments on that everybody, I'm sorry. What would be recommended? Let's roll, 1 week. Yes, sir.
All right. Without objection, we'll roll it 1 week.
Okay. Thank you. Thank you, Mr. Chair. Thank you, members.
All right. That brings us back to the hill of the calendar, which is item number 3 by Representative Rudd. Chairman Rudd, you're recognized on House Bill 1882. We do have a motion. Do we have a second? Do we have a second on House Bill 1882? Second. We have a second. Chairman Rudd.
Thank you. Thank you, Mr. Chairman. This is this gives very limited liability protection for snow removal. This is brought to me by Tennessee Snow Removal people. And this is only the way the best is described to me by legal, and it is a good example. It does not relieve them from liability protection from their own negligence, but from the negligence of the property owner or what limitations are in the contract. Good example that would be if a shopping center tells a snow removal company that they can't remove the snow until it's 2 inches on the ground and someone's harmed during the 2 inches snowfall, they're not held liable. If it's some other limitation or something that the property owner has put on the snow removal people, that only the property owner would be liable for that. But their own negligence beyond that would still be in effect.
All right. Do we have any discussion or questions? Representative Clement.
Yeah, Mr. Chairman, I'd love to hear from the Tennessee Bar Association if they're present, if we can go out off the record.
Tennessee Bar Association. I don't see them.
Well, I don't think they want to go on the record as well. Okay. Well, back on.
You're recognized, Representative Clement.
Thank you. So the bill, from the way I understand it, is wanting to deem the service contracts that these companies enter into null and void. Is it the current ones or the future ones?
Chairman Rudd.
No, that isn't what it does. It doesn't make a contract null and void. It simply says is the contract by the property owner or the client limits or causes harm that's not at fault of the snow plow people, that they're not liable for it, the property owner is. And the contract, if they put limitations on them that they're not to they're not to remove snow from certain parts of the parking lot, but others, and someone's harmed on that, they're not liable for that. And what's causing this is a lot of large corporations are coming in and offering the property owners that they'll cover them for everything, while the local Tennessee property snow removal people, which are often wrecker or construction companies that put the plow on to help out their neighbors, especially in small towns, that they can't compete with that. So this is simply stating that if any injury or any damage is caused, not by the snow plow people, but because of the contract of the property owner, they're not liable. But if the snow plow people is negligent, they're still liable.
Representative Clemens.
So the law as it currently exists, if someone hires a service provider to come perform services on their property and the person who hires that service provider is negligent or otherwise and results in harm to that service provider, do they not already have a defense or protection under the law?
Chairman Rudd.
I'm not sure exactly what your meaning is. I think right now as people are being sued, not in a large number, but they're being sued for anything, they're suing both the property owner and the snow plow operator when it's not the snow plow operator's fault. The negligence is not their part. We're simply stating that if this is caused by the property owner or the client, that they're removed from the lawsuit, unless they personally have caused negligence or damage on their part.
Representative Clemens.
So in your bill, the hypothetical is if the service provider is injured, who's the injured party under your hypothetical situation here that you're trying to protect?
Chairman Rudd.
The service provider is not about this. This is about if a third party is injured, let's say a customer or someone shopping at a shopping center. And this is caused not by the snowplow removal, but by the property owner. They can sue the property owner, but not the snowplow operator. Now, if it was caused by both, then they can sue both. But right now, I think if someone falls on, say, a sheet of ice or snow, or their car slides in, they're suing both. They go in and sue the property owner, and they're suing the snowplow operator, saying you didn't remove the snow properly, or you didn't remove it when it was 1 inch. And he says, well, I'm not allowed to do it until it's 2 inches. We're just removing them from liability.
Representative Clemens.
So if your bill were to pass, you would be saying that operator or service provider can't even be named in the lawsuit? Because the discovery process of a lawsuit is to try to figure out who is at fault and determine who is the direct approximate cause of that harm. So how are you going to do that at the outset before that process ever takes place? And I understand, I'm all for protecting small business owners and Tennessee-based businesses, but the system is designed in the way that it is designed for a purpose, and the discovery process is very important to determine exactly who is at fault. And I can tell you, once you discover that as an attorney, if you bring a lawsuit, and I have first-hand experience of this, you don't mess with the party that's not at fault anymore. It's a waste of your time, your resources, and everybody's energy. And you want to find out as quick as possible who was at fault. So I think your law, if enacted as written, would completely throw that process off kilter. And I appreciate that it's well intended, and you want to protect this entire industry from if they're not at fault, but you don't know if they're not at fault until you begin the process. And so that's my concern with the legislation as currently drafted. And please feel free to respond to that. But, Mr. Chairman, I want to ask, once he responds to that, if he chooses to do so, that we go off the record, and I want clarification as to whether or not the bill says that the contracts are void after he responds.
Chairman Rudd, would you like to respond?
Well, I think it's like any other legislation we passed up here that states that certain parties aren't to be sued. It still goes before a judge, and the judge decides whether it's within law. Right now, a judge has wide discretion. This would limit that and say if they're not at fault, if it is the fault of the contractor or the vendor, that the judge would automatically throw it out. If not, they would determine that it is and it could go forward.
Thank you, Chairman. And Representative Clemens, you have anything before we go out of session to legal? No. Okay, without objection, we're out of session.
Michelle Fogarty, Legal Services. The bill as written states that a provision in a snow removal and ice control services contract is void and against public policy if the provision requires a service provider to indemnify, hold harmless, or insure the service receiver against damages arising out of bodily injury to persons, damage to property, or economic damages caused by the service receiver's negligence, and the service provider has been directed by the service receiver not to perform snow removal or ice control services. That's the extent of the language.
Any questions for legal? Representative Clemens.
Thank you, Mr. Chairman. I don't have a question. I just want to say that based on what she just read and summarizing this legislation, there are so many slippery spots and holes in this legislation that I can't vote for it as currently drafted. Thank you.
And Representative Ogles, is your question for legal? No. Okay, seeing no questions for legal, we'll go back in session. All right, Representative Griffey.
Thank you, Mr. Chairman. And to the sponsor, Chairman Rudd, I appreciate you bringing this. My concern, I share with Representative Clemens, is that the fact-finding process to find out who's liable is often a question of fact based upon a number of circumstances. And the way these contracts are written, whether a service provider is required to indemnify the property owner who's hired for a job or whatever, you know, there can be back and forth as to whose fault it is. And I feel like that these are affirmative defenses sometimes against other parties, and what we're doing is we're kind of putting our thumb on the scale in one party that maybe it's warranted in some situations, but it may not be warranted in other situations. I think our current system works pretty well, and so I'm really hesitant to alter that system, and therefore I don't think I can support it, but thank you very much.
Chairman Rudd. All right, Representative Ogles, you're recognized.
Thank you, Chairman, to the sponsor. I kind of said this earlier, but this again seems like a carve-out. You know, me being a general contractor and providing services to property owners and landlords, I mean, I would love if every contract I had was clearly spelled out and I was held harmless for some of the actions that we encounter. But we have professional standards and we have licenses, and once we see something, you know, we're compelled to disclose that and get that taken care of. I just feel like this, once again, if we start this with snow removal, we'll have a piece of legislation from every subcontractor, every contractor that sets foot on a commercial property wanting to be held harmless, and there's a lot of them out there. So for that reason, I won't be able to support this legislation. But thank you. I understand your efforts.
Chairman Rudd, would you like to respond?
Again, this is I think a lot more is being made out of this because I realize certain professions want to be able to sue, but this is a very, very narrow defined piece of legislation that is very pointed and very plain, in which it says that the contractor cannot be held liable for the acts or limitations put upon them by the property owner. And that's all it does. It doesn't go beyond that.
Thank you. And Representative Garrett, you're recognized.
Thank you, Mr. Chairman. Chairman Rudd, thank you for bringing this legislation. I think I understand what we're trying to create here, but to kind of hone in on what Representative Clemens was saying, it sounds like we have a question of fact here that is going to, if we're trying to save a party from being sued, the service provider in this sense, because the property owner directed them, let's say they directed them to plow one portion of their parking lot. If you're at a Walmart and they plow one portion of the parking lot, but they don't plow the other at the direction of the Walmart owner, whoever that may be. And yet, me and you hopefully would park on the plowed section of the parking lot because that's the safer to traverse on. But there's going to be some that say, no, you know what, I'm going to do some wheelies over here on the ones that it's not plowed. And then they fall or damage something and create some sort of liability because this particular parking lot wasn't plowed. I believe what you want your legislation to do is say you can't sue the snowplow company because they were directed only to plow one half, not the other. Your action lies with the property owner. So therefore, they can't be named as a defendant in that particular hypothetical. Does that describe what your legislation is trying to do in that particular hypothetical?
Yes, and Mr. Chairman.
Chairman Rudd.
Yes, and what's happening, as has been pointed out in previous testimony, is certain jurisdictions or judges, when it's left to their own discretion, may go beyond that and go ahead and hold both parties liable, regardless of the direction or the intent of what the property owner said or was written in their contract. So this is just trying to give a limited, very tightly described protection for the contractor who is in no way at fault here. Now, again, if they are at fault, then they're still held liable and can be sued.
Representative Garrett.
And you've brought up my concern is that what's the bill doing because both parties are still going to be sued. That's a question of fact. If it's a jury, it's a jury question. If it's just a judge sitting without a jury, it's a question of fact for the judge to determine. So that service provider is still going to be sued and has to defend itself to say that they told me, the owner, property owner, they told me not to plow that particular side of the parking lot. That's going to be summary judgment. That's going to be a motion to dismiss. So they're going to be sued anyway. So I'm concerned on what we're creating because we're not preventing a lawsuit here. That's a question of fact. Public policy can certainly be within the state that this particular policy is against public policy. But again, that's a fact that has to be proven so the judge can make that determination. So I guess I'm skipping where we start with the particular hypothetical and then what we're trying to provide that service provider because litigation is still going to ensue regardless of this legislation. And so that's why I'm kind of not connecting what are we actually providing to the snowplow company under this legislation because they're going to be sued anyway.
Chairman Rudd.
Again, any law, as you know, any law that we pass, people can still sue. But if the law is in place, the judge says, well, there's a law preventing this, and they immediately dismiss it. And it's not just left up to their discretion. Whether it's a protection against someone being sued or a protection on some other act, if we have it in law, you can still bring a lawsuit and take them to court. But in most cases, or if not all cases, if there's a law in place, the judge is going to immediately dismiss that party, and it won't continue. If it's not in place, then it's up to the judge to go ahead and let the whole trial or the whole case go forward, and he or she will make that decision. Also, the other thing at hand here is what I said earlier. We have out-of-state contractors coming in offering liability protection for both sides, and the local contractors, especially in small towns, can't meet that.
Representative Garrett.
They're offering protection to parties, even if it's in the contract. The large corporations, out-of-state companies are coming in and offering liability protection for even if it's not their fault. So we're just trying to define this to protect Tennessee contractors.
Representative Garrett.
Thank you, Mr. Chairman. And I appreciate that particular point that you make, but I do have some concerns that I'm still not understanding what we're going to be providing to either an out-of-state contractor or an in-state contractor because the lawsuit's going to be ensued anyway to determine who's liable. And under our system, both the service provider and the landowner can share some fault, whether it's 50-50, whether it's 75-25 or whatnot. That's, again, going to be a question of fact on who's liable. In my particular hypothetical, I could make an argument that the service provider alone was negligent by not telling the landowner that you need to plow your entire parking lot because people are going to be parking unless you decide to close that particular side and have signs that say no parking. I just think we're opening up more or potential more litigation on that particular fact on who's liable. Because believe me, when you have multiple defendants in any lawsuits, what's the first thing they're going to do is point to the other defendants. I'm not at fault, they are. And that's kind of what we're creating here. So that's why I have some concerns on the legislation. But thank you for bringing that. Thank you, Mr. Chairman.
Chairman Rudd, do you have anything else? And Representative Parkinson. Okay, thank you. I'm not seeing anybody else on the list. This is House Bill 1882. We'll be voting to send House Bill 1882 to the Civil Justice Full Committee. All those in favor signify by saying aye. Opposed, no.
No.
Bill fails. Next up is item number 4 by Chairman Rudd. Chairman Rudd, you're recognized on 1884. Do I have a motion and a second? We have a motion. Second. And a second, Chairman Rudd.
This is more of a 1884 is more of a cleanup bill. A couple of years ago, 2 or 3 years ago, we passed legislation that if you have a landlocked piece of property that was obtained by fraudulent means, we reduced the easement from 15 foot to 10 foot, so it couldn't be fully developed. But accidentally, not a part of that, we also, in the original law, we removed a judge's discretion under special circumstances to allow a 15-foot easement. This is brought to me by utility companies because they have had several pieces of property that they could not run utilities to because they didn't have enough easement. It's 10 foot for the road, and they can run power or water or sewer, but they can't run all three with just 10 foot. So, and we took away the judge's discretion, and this restores that discretion.
Do we have any questions or discussions? Representative Clemens.
Is the landowner going to be compensated for this additional property?
It's same as it was under the current law. They are compensated. As you know, any landlocked piece of property has a right to access, and it's usually wherever it's easiest and best and least intrusive on the neighboring properties along a fence row, and they're usually, whatever rule is currently in place, it doesn't change that.
Representative Clemens.
Is it your intent for them to receive further compensation in order to facilitate this additional easement?
If they were compensated, if the court or the agreement compensated them 10 foot, then they would have to be compensated for the additional 5.
Representative Clemens.
But right now, they can't even request the 5.
Okay, thank you.
Okay, Representative Griffey.
Thank you, Mr. Chairman. Thank you, sponsor, for bringing this. Do we have any utility companies here by any chance that could expand or explain a little bit on the easements with the pole and water stuff by any chance? I'm just
Not
curious.
to my knowledge, no.
And I'm assuming, they put, if they're running power, you got your big pole going in the ground, and then 10 feet's not enough to separate a sewer line and then a water line running in. So it's a problem. But it's also my understanding that the power companies typically like to have a paved road, or not paved, but a road, gravel, or some way where they can get access to the poles and the lines overhead and so forth. So I'm going to support this bill. And so thank you, Mr. Chairman.
Thank you, Chairman Rudd. Do you have anything?
Yes, and all the current rules of granting easements to landlocked property is still in place. This doesn't change anything. And a lot of that is determined by the utility companies themselves, what their rules are. If they want it paved, or they want it graveled, or they wanted a certain squidage, they're not going on there. We can't make them go on and provide it. This is just giving a judge that discretion under certain circumstances that the judge may deem appropriate, that he can grant the 5 foot.
Chairman Ramsey, I got you next.
Thank you, Mr. Chairman, and I just, by personal experience, I can tell you that the law now does require that you be reimbursed for land that's taken that way, because I've experienced that myself.
Chairman Rudd, do you have anything?
No.
Okay, Representative Vogels, you're recognized.
Thank you, Chairman, and to the sponsor. I'm reading the language. Are we widening it 5 feet or 15 feet?
Chairman Rudd.
We're widening it up to 15 foot as a judge. Again, we're not widening. We're giving a judge that discretion under these circumstances. A property that's normally landlocked, that there's no issue with its obtaining of the first sale or the second sale, could have transferred to a new property owner. whatever the legal circumstances was that the original law stated. Because remember, the original law stated if a land had been obtained through fraudulent means or illegal means or whatever in that property owner and they sell it, it's still that land is still. That's where a judge would come in and say, well, it's got a new property owner. You can't do that now because we took away. And what happened is a new property owner of a landlocked property came in, and he went to the judge to get the 15-foot. He says, under the law, they took that authority away from me. I can't do it anymore. So we're just giving the judge back that authority. Everything else related to the law we passed, if a property, and I haven't, since I'm not changing that part of the law, I haven't really gotten into that, but the law we passed where it says it's by fraudulent means or illegal means or questionable means that the courts may have ruled, that stays in place.
Representative Ogles.
Thank you to the sponsor. And we may just need to clarify with legal. I was just reading 25 and I saw 15 added, and I've got a piece of landlocked property that's got a high voltage line running through it, and if they decided to put a subdivision on the backside and the utility company wanted to come in and widen that easement, that would literally cut my building envelope in half and cause significant damage to the property. And I'm just trying to figure out if that's what we're doing to every landlocked property that has a line running through it, or if it's specific to that.
All right, without objection, we'll go out of session to speak with legal.
Michelle Fogarty, Legal Services. Under current law, a person owning land that is essentially landlocked has the right to a private easement or right-of-way not exceeding 25 feet. The language in this bill states that if a person is petitioning for a private right of easement for the purpose of, and they need additional land for the purpose of extending utility lines, including but not limited to electric, natural gas, water, sewage, telephone, or cable, then the person must include a request for additional land in the petition. The court may, upon a showing of good cause, grant the petitioner's request and direct the jury to lay off and mark a road that is 15 feet wider than that it is currently permitted, which would be 15 feet wider than the 25 feet already permitted.
Any other questions for legal? Representative Ogles, you're first.
So for clarification, we're not adding 5 feet to 10 feet. We're adding 15 feet to 25 feet. And that's, I want a clarification because that was not in the description as it was presented. So that is a significant increase in the easement that's being allowed.
Excuse me. Current law provides for not exceeding 25 feet. The language in this bill states that the court may direct the jury to lay off a road that is 15 feet wider than is currently permitted.
Thank you.
Representative Griffey.
Thank you, Mr. Chairman. The question for legal is the part about the law we changed last year about if someone had detained the property fraudulently or sold the property fraudulently, indicating there may have been an easement or something. Can legal give us any clarification on that? Because it sounds like if the owner couldn't get the easement because they obtained it by fraudulent means or something, now they're going to be able to jump out of it simply by selling it to somebody else. And then a new party is going to be able to force the easement that the original owner could not have gotten.
The statute that was passed in 2020 states that notwithstanding section 54-14-102, which is the one that allows the 25 feet, there is no right to have an easement or right-of-way condemned and set aside for the benefit of the land surrounded or enclosed by the lands of any other person if the court determines that the ingress or egress to and from the surrounded or enclosed land is cut off or obstructed entirely from a public road as a result of the intentional and knowing act of the owner of the surrounded or enclosed land. So there's no right if the land is cut off as a result of the intentional and knowing act of the owner.
Owner of the surrounding or the owner
of the surrounded or enclosed land.
Representative Griffey. All right, Representative Ogles, you're recognized.
This is illegal, and this brings up, this was my question. I believe Judge Carter was involved with this legislation, and we had a discussion on whether this wiped out easement by necessity. Was my question then, even though a piece of land was carved out, so future owners down the road, and that was my big concern then, is if in the future, if all the rights of easement by necessity, I believe, would be wiped out with that piece of legislation. Does that make any sense?
It states that the cutoff would have to be the result of the intentional and knowing action of the owner of the land. So if the land was sold and a subsequent owner purchased it, I'm not sure that would be their intentional and knowing act. But that would be a question for the court.
Chairman Curcio, you're next.
Thank you, Mr. Chairman, and this is shifting gears from the most recent line of questioning, but and I apologize if this is a dumb question, but does this bill provide, so if I've got 25 feet and I need to go back to get 15 more feet for utilities, I'm petitioning the court for that. Is it the same easement, or could it be a totally different route?
The language as written says to mark a road that is 15 feet wider than is permitted. So I would be up to a court to interpret that as to what,
but the language says 15 feet wider, so you would think if they've already carved out a road that's 25 feet wide, they're just making it wider, not a brand new route.
It doesn't provide, the language as written doesn't provide for a new road. It just says 15 feet wider.
Very good. Thank you.
Representative Griffey.
Thank you, Mr. Chairman. This is for legal. So a landlocked owner intentionally does something to cut himself off or the access off. He can't get an easement, but he can sell it if we pass this measure. If he sells it to somebody else, the new owner is going to be allowed to come in and get the easement, despite what the original owner or seller of the property did. Is that correct?
That's ultimately for the court to determine. I can tell you that the language of the statute states that if the land is cut off or obstructed as a result of the intentional and knowing action of the owner of the surrounded or enclosed land.
So it sounds like to me that if you have some land, somebody owns some land and they intentionally cut it off, we just pass a law that says you're not going to be able to get an easement because you did that to yourself. And then what if we pass this? All this owner has to do is transfer it to a new person, new party. That party could transfer it back. It's just a way to circle around what we originally passed in 2020, sounds like.
TCA 54-14-102 states that a person owning any land where the ingress or egress is cut off and has no outlet to the public road is given the right to have a private easement or right-of-way. The statute I previously read to you said notwithstanding 54-14-102.
Okay. Thank you, Mr. Chairman.
Representative Clemens.
Yeah, thank you. Thank you, Mr. Chairman. I guess the question I have, and I hope we're not getting this wrapped around the axle, I don't know why this would just now be a problem right now unless we created this problem when we passed the previous legislation. So my question to legal is, this was represented as a fix to a problem we created with legislation a year or two ago. Is that simply what we're doing here? We are correcting something we inadvertently did, in your legal opinion?
I can't speak to the intent or give opinion. I can just tell you what the law states. Currently, under current law, you're entitled to 25 feet for the purpose of ingress and egress and extending utility lines.
Okay, well, I get, my concern is if we're just fixing something that we messed up with previous legislation, I get that and I understand that. Otherwise, I don't know why this is just now coming about now in 2022. This has been the law for a long time. So that's my concern. And if legal can't speak to the limitations of the law, the bill as written, that concern remains. And once we go back into session, the sponsor can respond to that, I guess.
Okay, Representative Vogels, you got something for legal?
Well, I still have the question, this is going to pertain only to those specific landlocked properties. We're not going in and blanket granting easements to be widened from 25 to 40 feet to all private landowners across the state. If any utility provider simply states a necessity to expand their services? That's my question to legal. Is this limited application only to these specific landlocked properties? Are we kind of blanket gonna grant our utility service providers the ability to widen their easements from 25 feet to 45 feet across the state if they articulate a necessity?
The language in the bill amends the statute regarding a person owning a land where ingress or egress is obstructed or cut off. So it states that if a person petitioning for a private easement or right-of-way needs additional land, they have to include that in the petition, and the court, upon good cause, may direct the jury to grant the additional 15 feet. So it's within the statute that deals with granting a private right-of-way or easement to persons who are landlocked.
So I had one question for legal. So if current law is 25 feet, with this additional 15 feet, is it possible that the easement could be 35 feet total? Or 40 feet?
Subsection A of 5414-102 gives them the right to a right-of-way not exceeding 25 feet. This language would add additional 15 feet to that.
So a total of 40 feet total. Okay, Representative Parkinson, you're recognized.
Thank you, Mr. Chair. And so I want to be clear on the property obtained by fraudulent means. What exactly is meant by that?
The statute doesn't use the term fraudulent means. It just states that if that there is no right to an easement or right-of-way if the land is enclosed, if the enclosed land is cut off or obstructed from a public roadway as a result of the intentional and knowing action of the owner of the surrounded or enclosed land.
Okay. And then if we pass this law, then that that owner that intentionally landlocked the property can then transfer the property to his son or someone else, and then they can petition the judge to open it up.
This law, the language in this bill doesn't impact 5414-119. It just allows an additional 15 feet on top of the 25 feet that's already allowed for a person who owns land that is essentially landlocked.
For the new owner, correct?
5414-102 states that a person who owns property that has no ingress or egress is entitled to a 25-foot easement.
Okay.
But in this one's
go ahead. I'm sorry.
5414-119 states, notwithstanding that statute, if the property owner is the one who cut off or obstructed the land, then they're, as a result of intentional or knowing action, then they are not entitled to an easement.
Okay. And then with this legislation, if that property is sold under this legislation, they would then have the ability to petition the judge. Am I way off?
This legislation is just allowing an extra 15 feet on top of the 25 feet that's already allowed.
Okay. Thank you, ma'am.
Okay, members, we're coming up on our time, and Representative Rudd, can we go back in session? Then we'll decide what we go. We're back in session. All right, Representative Rudd, we're pretty close to being out of time. Would you
won't take me a second. Number one, this legislation as written is not what I instructed legal to write. So I'm going to ask to roll it. What has been put in here is I asked up to 15 foot for land associated with this law, and most importantly, to restore a judge's discretion. I didn't ever say I wanted it 15 foot beyond the 25 foot, because under the current law, if you've done it, you're only limited to 10 foot as punishment to access your property, but you can't run utilities. Utility companies want the additional 5 foot if a judge grants it. That's all I wanted. This law as written apparently is going beyond where I wanted it, so I'd like to roll it a week.
Well, thank you, Representative Rudd, for that. Without objection, we'll roll this bill 1 week. And without objection, we will go out of session, or we'll adjourn.